I just like a few months ago, finally after all these years, had a juror who actually like said it out loud. We were picking a jury in a case and we were asking, are you open to the possibility, that this could be millions of dollars? And one of the jurors said, well, it depends on what the defendant did, and the judge was like, no, that's not, but it's like, that's what I've been saying for years. That's what jurors feel.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, we're back, RVA Trial Lawyers, and today we are joined by Harry Plotkin. As I've told Harry now many times, I am a massive fan. I saw him speak back in October of 2022 at Trial Lawyers University, gave me an entire page of notes that I immediately emailed to my firm saying, hey, we've got to do some of the things that Harry's talking about. I still have that page of notes here with me today. The things that he taught me back then and that I've continued to learn from him have greatly influenced how I've gone about handling my cases. So, Harry, really excited to have you. And if you wouldn't mind, go ahead and introducing yourself to our listeners.
Sure. Happy to be here, guys. Honored that you guys had me on. I always love to, and I love hearing stories about when people thank me for something that they've picked up over the years because, I wish I could clone myself and be in everybody's trial, but, so I love it when I hear that I'm influencing people's careers and trials with the teaching that I do. So yeah, I've been a jury consultant for 20 something. I don't want to date myself exactly, 20 something years now. Years ago, when I first started doing this, I would pretty much work on any kind of case, criminal, civil, defense, plaintiff, could be a PI case, or it could be a breach of contract, commercial case, any kind of case. I couldn't turn down cases. And then over the years, I've kind of developed into I don't really like doing this. I like doing this. So I focused on civil. I stopped doing defense work. I stopped doing commercial stuff for the most part, every so often if something really interests me. But for the most part, I just only will work on the plaintiff side, love helping people. Cases where I think that public safety and people's rights, employees' rights, civil rights are affected. Those are the cases I love doing. So I've been doing that. I've probably been doing plaintiff only for about 10 years now. And I just love being in the courtroom. I mean, I know that there's some wonderful consultants and people in this area that aren't lawyers that teach lawyers, but I don't really want to be one of those ones who just workshops things. I want to be there in the courtroom actually picking a jury. That's what I love to do.
It's awesome.
Harry, you don't wake up saying, hey, I want to be a jury consultant. How did you become a jury consultant and what led you down that path?
I think I was probably doing this longer than I realized this is what I wanted to do. So I kind of fell into it. And I have a background in psychology. It just so happened that I was working with some lawyers at a previous job, working for some experts that were picking my brain on how to present things to juries. And then it just so happened that I knew some folks that were starting a jury consulting company, asked me to join them. So I just totally fell into it and kind of was in the background for a few years, learning the ropes until I started my own practice. But even then, even when I started being a jury consultant for a few years, it took me a while to figure out what I loved about it and, loving helping people and making a difference. And it took me a while to realize like there was one side that I really wanted to work on to help me sleep at night and really love what I did because, at first you kind of win or lose some trials, but you don't really think about the impact it has on our community, on society, and how, holding bad guys and companies fully accountable when they cut corners. But eventually, now that I've been doing this a long time, it's just something I would never stop doing.
Harry, what does a jury consultant do? So, it's not just in the courtroom helping select a jury. There's case framing, there's focus groups, there's there's all types of stuff. Can you kind of give us a sense of what your job entails?
Sure. Yeah. You're right. It's any kind of advice that I can give to the lawyers to help them understand their jurors, get a good jury, and win over their jury is something that I can help with. Yeah, exactly. Whether it's opening or framing or, sometimes it's just like, here's how you strategically, you got to focus on this. And what you're focusing on now, for example, is really not going to get jurors upset. And this will. And so, finding the piss off points, but also helping them. I write the voir dire questions that the lawyers that I work with typically ask. And I'm there in the courtroom, obviously picking the jury and deciding who I like and who I don't like and assessing everybody. But yeah, running focus groups and just helping with anything. Even doing some witness preparation at times and, helping to structure an opening statement because the way that you tell the story is a huge part of it too. So anything to do with helping get ready for trial is something that a jury consultant can help with. And like I said, I know there are some who don't really focus on being in the courtroom, and that's great too. Some of them teach presentation skills. Some of them teach how to frame, but don't necessarily pick the jury. So there's so many different ways that people who just do this all the time can help. But for me, I think my strength is understanding jurors, understanding how different people will feel, hey, I mean, your perfect juror is going to feel this way, but other people are going to be focused on this and react differently. And helping the lawyers to present it in a persuasive way to the full spectrum of people is what I love to do.
My thought is that you are probably, well, we talked before the call that you're jumping around to 20 plus jury trials a year, if not more. So you are getting to see a different jury, gosh, every other week, more or less, and different sets of facts, different sets of focus groups. Whereas the average civil trial lawyer, I mean, if you're getting in front of a jury more than 2 or 3 times a year, that's a hell of a year for trial experience. So it's interesting, but it's somewhat, I don't know if counterintuitive is the right word, but like, I don't think one would think, oh, wait, this jury consultant would frankly have better advice than the lawyer's experience. But then when you take a step back, you're like, wait, this jury consultant sees what works and sees what doesn't work almost every week, if not every other week, whereas the lawyer doesn't, then it makes sense. It makes sense, right?
Right. Exactly. And it's not just the number of trials. I think it's probably getting close to 1,000 juries that I picked in my career, or will be at some time in the next few years or something. But it's also the focus groups, just seeing jurors talking about reacting to cases and what they say and how they talk about it is just as helpful in jury selection, because it helps you understand, like, okay, this is how some people feel and why do they feel that way and who feels that way. And so just when I hear a juror talking in jury selection about something, I can pick up on little things that they're saying that I go, I've heard a version of this little talk, 50 times before. And the trial lawyer maybe hasn't, even if they've, picked a number of jurors, because I've just seen so many jurors talking and I've seen so many trials and so many jury selections. So even little weird things I can go, that may sound like a good thing, but let me tell you why that's actually a bad thing that they said. And so, yeah, just the reps is a huge part of it. And just hearing, thousands, I can't even, if I were to count the number of jurors that I've heard talk, it's in the 100,000 probably.
When you say pick a jury, practically, what does that look like? My understanding is that you're not necessarily in the courtroom asking the questions, picking the jury, but you're kind of like at the table or behind the bar, passing up stuff. Like practically, what does that look like?
Yeah, I'm not asking the questions. I'm not a lawyer, so I'm not allowed to do it. But I've written the questions and I'm there almost always at counsel table. And if necessary, I may write little notes. I don't like to write like a ton of notes, just be feeding people paper in front of the jury so the jurors looking at me all the time. But if there's something like, I think, no, you got to ask it this way to get this guy off for cause who we're struggling with a little bit, or, ask these questions or talk to these folks about damages, I'm also there handing notes. But also, I'm the main one observing the jurors and interpreting what they say and assessing everybody. And so as soon as the lawyer that I'm working with sits down, I have the sheet of like, here's all the people for cause. Here's exactly what they said. Here's our strategy for who we're selecting and who we're keeping. And, if you have a case, which happens all the time, where, for example, 6 strikes in California and there's 8 bad jurors, and it's like, here's the ones that we could probably live with because you're not going to be able to probably strike them all. So when I say selecting a jury, it's like, I love to be in charge of that. And a lot of the lawyers that I work with just love delegating that part. They'll get them talking, they'll get the information out there, and then it's like they rely on me to put together a good jury and tell them who to strike and who to keep and when to pass and all that kind of good stuff.
Do you think it's important for the trial lawyer to do the voir dire? Meaning, like, would it be a detriment for, let's say, someone to just come in and do voir dire and then leave, right? Because my thought is, and I think Niall and I talk about this all the time, one of the goals of jury selection is building that rapport. It's developing that credibility and trust, right? Is that fair?
Yeah, I agree 100%. I have seen it where someone else does it and then leaves or has a minimal part in the trial. I don't think it kills your case, but I do think it's important. It's a little weird when that person that you build rapport with is gone, and I think it helps to have the trial lawyer. Now, I've seen a lot of cases where there are a couple of people who are kind of sharing the load. It doesn't really matter. I don't think which one. You don't have to have the person who's doing the opening necessarily do the voir dire, but I would recommend if you're trying the case, you should do the voir dire.
That makes sense.
We can break it down a little, simplify it a bit. So when you get a case, they're reaching out to you to consult in regards to a case. What is the first thing you're looking at? Are you looking at issues in the case? Because you talked a lot about the feelings. You're not talking about the law, and you're not talking much about, what facts or affirmative defenses there are. You're talking about feelings. What are you looking at when you get a case? How do you start framing the case?
Yeah, it's a great question. I mean, I like to get something about what each side is kind of saying happened. I think that you pick a jury based on that weird area of the things that both sides agree happen, but it's just a dispute about what should have been done, what's reasonable. A company is like, yeah, we did this, but we didn't have to do this, and it's okay to do it. This was safe enough. And the plaintiff is saying, no, that wasn't safe enough. So there's always whenever I'm giving advice on framing For example, for me, framing is how do you tell the story in a way and the liability in a way that even if you believe everything that the defense says, it still doesn't matter. There's still a fault. That's the way you really get a great verdict so that, you go, yeah, even if everything the defense says is true, that's still not good enough. And so I really want to get a sense of what each side is really saying. Was responsible or wasn't responsible? Obviously, every case is different, but I'm looking at what the two competing narratives are and trying to figure out who are the jurors who are they're not okay with it. Whatever the defendant did falls short of their expectations. Or for some jurors, which are the ones who are going to say, that's fine. I mean, a good example is like somebody, let's say, comes with like an injury to the ER and they don't get treated for hours and there's a delay in diagnosis and delay in treatment. And some jurors who have been to the ER and have had to wait for hours, they're not really great jurors for you on the plaintiff side because they're like, that's exactly what happens. That's not a big deal. That's not surprising. I want the jurors who are going to go, I would expect that I'm going to get treated within 30 minutes and I'm shocked by this. And so sometimes it's counterintuitive because sometimes I think plaintiff lawyers expect that people who've had negative experiences are going to be good for you. But I'm always thinking about what the jurors' expectations are and how that compares to what actually happened in the case. Some of the things that I'm thinking about when I'm assessing a case and trying to figure out the strengths and weaknesses or the piss-off points, because you're figuring out the piss-off points, what's going to really upset a jury, but also what kind of people are going to get pissed off and what kind of people are not going to get pissed off. I think in criminal cases, the burden of proof in the law are a little bit more important than in civil cases. In civil cases, it's, preponderance. It's kind of a toss-up. It's kind of up to you. I mean, to me, a lot of times it's like, it's up to you, the jury. I mean, you can kind of do what you want because preponderance is such a low standard. Criminal, I think the law is more important. You're looking for a little different kind of juror. It's not just how they feel about it, but how they feel about the concept of someone's rights and burden of proof. And you are looking for people who can stick to it, even if they kind of feel like, I think this defendant probably is guilty, but that's not enough.
You talked a little bit about, or you mentioned a few times now, piss-off points, making the jury upset.
Yes.
Can you dig into that a little bit more?
Yeah, I mean, I think one of the things you're always looking for on the plaintiff side are, what are the real piss-off points? What are the things that you really trigger and upset a jury and they're going to be angry about toward the defendant? Because if you don't have those, or if you don't emphasize those, or you emphasize something that doesn't really make them mad, the reaction and the verdict is not going to be nearly as good. There's some things that I always tell people to do because you want them to maximize their anger at what the defendant did. You want to frame your case around a choice that they made as opposed to just an accident. And like one example is I'm working on a case right now where there were a bunch of different theories of the case and the lawyers are kind of saying, well, we're going to kind of get rid of those theories and proceed this is a product liability case on strict product liability. But it's a case where the defendant in the case, the part that was defective and actually caused a wrongful death, they didn't build that part. They bought it from a supplier and they're kind of going on this theory that, they're strictly liable for it. And what I'm trying to do is I'm finding ways to really find the piss-off points because I'm telling these guys, technically that may be true and you'll probably get a verdict, but these jurors are just not going to be that upset if you're just saying, hey, there's no way we could have inspected it. There's no way we could have figured out there was something wrong with the product. But at the same time, you're just strictly automatically responsible for it, even though it's this other company's fault that, by the way, already settled out in the case. So you're always looking for how do you frame the case in a way where they really feel like the defendant did something wrong? Because we just find over and over again, damages where they take it out. If they feel like somebody is technically at fault under the law, but it's not really fair, it was an honest mistake, in a car accident, this is just an honest mistake and they didn't mean to hurt anybody, and or it wasn't really their choice, they didn't intentionally do it. You may get a verdict, you may get defensed, or you may get a verdict, but it's going to probably be a pretty small verdict. Whereas if the jurors feel like they did this, they were careless, they kind of made a choice and they did something that really, really upsets me, they're going to take that out on the defendant in damages. Because one of the things that I always use to frame damages in jury selection, and I always tell the lawyers to do it throughout the case, is your verdict is the only way to hold a company fully accountable for what they did and the harm that they caused. And jurors care about that. That really gets jurors go, yeah, I want to hold someone fully accountable. But do they want to hold someone fully accountable if they think it was an honest mistake? You don't know. So those piss-off points matter, and you got to find them, and you got to figure out through focus groups or just through your own analysis, what's the thing that, some friends of mine will use the phrase like the thing that I just can't get over. I cannot get over the fact that they didn't test this, right? I can't get over the fact they didn't do a background check on this teacher, or I can't get over the fact that somebody made a complaint and they just sort of didn't investigate it. So those are really important.
Yeah. You know what I found? So I have found that whenever you see a kind of a massive verdict in the news, oftentimes you can find one of those piss off points, right? Like an example I use, and I've mentioned this so many times that I'm sure I'm going to get the numbers wrong, but like there was a case in Texas, I think it was against Charter Communications a few years ago. A lady was killed by a technician who was at the house, I guess, to do some cable work. And I believe the technician had a criminal background. Well, I think the Texas jury came back with like $200 some million compensatory and like $7 billion punitive. And the argument that I make to people is like, listen, like any given wrongful death, you're not going to necessarily see that. Why do you see such a big verdict there? It's because Charter Communications hired this guy and they knew better, right? He should have never been there, yet this is what happened. And so that was the piss off point that I think led to such a high verdict. You look at the Alex Jones case with the Sandy Hook stuff, right? I mean, close to $1 billion verdict. I mean, it's right. And I've found a lot of resistance, certainly when I've tried to do that. So now I do it without telling anyone I'm doing it. And right. So, but I mean, but to some extent they do it to themselves, like a car wreck case, right? Simple car wreck case, car crash, lady has hip surgery. Let's say 3 months later, defense says, oh, we hired this doctor who says, yeah, she should have been good to go 6 weeks after. This hip surgery, degenerative, not related. Well, they just created the piss off point, right? Because now it's, wait, so just because she's 44, she had to have hip surgery? Like, is that what they're saying, right? And so in some respects, I think sometimes the defense kind of does it to themselves.
100%.
Do you see that?
Oh, yeah. I mean, I don't think that you can get a really, really big verdict in any kind of case without the defense lawyer helping you out. If every defense lawyer was reasonable and took responsibility where there should have been responsibility taken, even with the most egregious conduct by the defendant, if the person up there in front of the jury says, absolutely, we understand at this company that was absolutely irresponsible and everything. I mean, admitting liability brings down verdicts, and knowing not to step in it brings down verdicts. But that doesn't keep them most of the time from helping you out and calling the plaintiff a liar and calling a medical expert who's just full of it and tries to just cherry pick things and trick the jury and they get caught. I mean, there's a million ways that they just help you out. And so we need their help for sure to really piss off the jury, because if everyone was reasonable, I'd be concerned. And they should. I mean, that's what the defense should be doing. I don't know if we're here to teach civil defense lawyers, but I mean, it's true.
I don't even know if it's a civil defense lawyer. I think sometimes it's insurance company driven too, right? I mean,
it's not just them. Yeah.
Yeah. So I agree with you, Harry. I mean, I think the hardest thing for us to tackle on the plaintiff's bar is the defense lawyer who gets up and says, here's a checkbook. We'll write them a check for $300,000. They're asking for $15 million, right? Like, yeah. When we interviewed Joe Freed not too long ago, I think he really did a good job kind of crystallizing this point. But Niall and I believe that at the end of the day, the jury rightfully assumes or presumes that the lawyers and the judges know more about the case. So they're looking for a guide. They're looking for someone who they can trust as an advocate. And if you can win the, hey, we're here not because of us, because of them, we're the reasonable people, I mean, I think you're probably off to the races for a good bit.
Yeah. So, Harry, we're talking about the piss-off points, which is important. So how do you bring that up in voir dire, plant it in voir dire, and frame it in voir dire the way you want the jury to perceive it throughout the whole entire trial?
Good question. I don't like bringing up any of your good facts specifically in voir dire, because you're going to lose those jurors. As soon as the jurors hear a fact, even though it's not technically an evidence, they're like, oh my, they did this. I mean, I can't be fair. And in California, we have these mini opening statements that each side is allowed to do, required if they ask for it, where you get, a minute to 3 minutes to 5 minutes before voir dire to talk to the jurors. Hey, this is what the case is about. It's helpful if you do it right, but it's super dangerous if you do it wrong, because one bad fact that you let out of the bag, you're toast. You're going to lose all your good jurors. And I've seen it before when the lawyers kind of said, well, I want to tell them a few things, and they try to advocate too much, and you lose your good jurors. I mean, I had one where this employee got breast cancer and was on a medical leave during radiation. That's when they fired her, and we lost, a ton of jurors because of that. And I was going, no, you can't tell them that. So in terms of how you handle your piss-off points, the way that I like to do it is you start to subtly point the jury in the direction of where you're going. So I'll give you an example. Like in a mini opening, if I had a case where, let's say there was a sex abuse case against a school district, and our best fact is like 3 girls come forward over the last few years and said, hey, he was making me uncomfortable, or he gave me a hug or whatever. And, red flags, but not, like smoking guns necessarily. And you don't tell the jury that, but in the mini opening, I like to say, you're going to hear all about what the school knew, what they were told, what they could have done. So you're just sort of pointing in that direction. Oh, this is important. You're kind of putting a pin in it. Another product liability case, you're going to hear about all the testing that they did or didn't do and what they knew about this product or what they knew what the dangers were. So you're not telling them what it is, but you're sort of teasing them a little bit about this is what this case is about. So jurors are going, well, what evidence is there? And they're looking for it. And then when you bring it up and you make the case kind of all about that, and then in your real opening, then that's when you let them know. But I'm not a believer in trying to win over the jury during jury selection. I think if by the end of jury selection, if your jurors think that you have the right, you're probably going to win. You're not doing it right. You're going to lose those jurors, and you shouldn't. You should be lowering their expectations. All the best verdicts that I've had in the opening statement, the jurors their like eyes are bugging out and their jaws are hitting the floor because they had no idea how strong. And they were going, oh my, and they tell you afterward, I didn't realize this case was so strong. And I can't believe I'm sorry that I kind of questioned it in voir dire, but then I heard your case in opening. So that's where you want them. You don't want to oversell it before you actually panel the jury.
Harry, that's good to know. See, in Virginia, we don't have that. So that opening is not there. So the questions where you try to at least plant the seed doesn't get them to the aha moment. Oh, we know what the piss off point is. So you can kind of touch on it and they're not going to really get it. So what you're doing is you're warming them up or priming them right until you get to the opening. And they're like, or you bring it back in closing and they're like, that's the reason why I asked you that question. And that's the reason why I got you to commit.
Exactly.
Right?
I mean, even though you're not feeding them the information, you're looking for good jurors and you're getting rid of jurors that kind of don't see eye to eye with you. But, for example, in a product liability case, like in this one I talked about, one of the main questions I want to ask is, what are your feelings about whether companies that make products should have to test those products as rigorously before they start selling them as they would after the fact if something went wrong and somebody got hurt? And you're going to get jurors who are going to say, absolutely. And you're not telling them, of course, that, hey, this product was barely tested or maybe not tested at all. But you're planting that seed and you're getting the good ones. And then anybody who says, I don't think they should have to do whatever the minimum standards are. Or I think an investigation after a crash is obviously going to be way more rigorous than testing before. Then we're probably going to not want those jurors and get rid of as many as we can. So you're feeling out how they react to some of those piss off points and the themes without telling them. And then once you tell them, hopefully you get that receptive audience because you've hopefully kept as many of those jurors that you can that really are going to get pissed off and find it important. But I wanted to tell you guys, it's funny. I mean, you brought up that article about every verdict being punitive. And I just, like a few months ago, finally, after all these years, had a juror who actually said it out loud. We were picking a jury in a case and we were asking, are you open to the possibility, that this could be millions of dollars? And one of the jurors said, well, it depends on what the defendant did, and the judge was like, no, that's not, but it's like, that's what I've been saying for years. That's what jurors feel. And this is the first time I've actually heard a juror say that out loud in voir dire. But it's true. I mean, for jurors, it's like, what's the difference between if a death is $1 million or 200 and something $million? Million's a lot of money. The only difference really is like, how much does this defendant deserve to have to pay it? And if they don't feel like they should deserve it, it's really easy to say $300,000 is a lot of money for a family over someone who died. And if they're really pissed off, they're going to be like, I want this to hurt. And they deserve to have to pay it. And it's especially important, that kind of concept, in cases where you're suing an individual and the jurors don't get to hear about insurance, and it's an automobile case, because it's harder to motivate them if it's not a company.
Massive difference. I mean, I think the soft tissue auto crash individual defendant case is very, very difficult to motivate. Totally
different in how you approach a lot of things. With what you're looking for in voir dire and how you're framing damages, because you can't get out there and say, how do you feel about millions of dollars to hold a careless driver fully accountable for causing a cervical fusion? I mean, people are like, fully accountable. It's like one guy, and so you definitely have to ask a lot of questions very, very differently in that case.
Harry, what are the goals of voir dire, of jury selection, if you had to distill them to a few points?
I think for me, the most important goal, there's nothing more important in a trial and your success in trial than having a receptive jury where you're not going to be just fighting an uphill or impossible battle with them. And so the most important thing is being able to assess every single juror, asking at least one open-ended question about liability and trying to figure out who is going to be upset and who's not going to be upset, who's got a really strong conscience about whatever criticisms that you're going to make are and who doesn't. And you got to ask everybody, because if you miss anybody, you can't just guess. You can't just say, well, that guy's an engineer, that guy's an accountant, and she's a nurse, and I'm just going to guess about those things. You have to talk to everybody. So if there's only one thing you could do, it's just get that information to assess your jurors and get rid of the worst ones. I think that building credibility is hugely important. If you rub your jurors the wrong way during jury selection, that's not great. I mean, obviously. And so I don't think that should be your goal, but I think that you need to find a way to talk to your jurors in a way that where they do like you and they trust you and they don't think that you're manipulating them, interrogating them, that you're actually interested in what they have to say. I mean, there's nothing worse than a lawyer on either side saying like, who's ever had a spouse killed? Okay. And it's clinically, instead of saying like, oh my God, it's horrible. I mean, can I ask you a few questions about that? As opposed to just, when did it happen? How much blood did he lose? Or whatever, like you're asking these questions like, wow, this guy doesn't care. So I don't think that's necessarily your goal, but you should always find a way to do it, because if the jurors don't like you and they don't trust you after jury selection, you're in a pretty deep hole. I don't worry about preconditioning that much. I don't think that there's much you can do to really take a lead in jury selection. All you can do is set yourself up for success in the other phases of the trial.
Well, the thought is that the idea that we can change someone's core beliefs, right, in the matter of a few hours, if we get that during jury selection, I mean, it's a fool's errand, right? Like you're not a 40-year-old who comes into jury selection, and if we think that we're going to somehow change their mind about certain core beliefs, I mean, it's just wrong, right? Like it's a waste. So the idea of like trying to change their mind or precondition, as you said, during jury selection really is kind of a waste of time. Is that fair?
I do think it is. I mean, there's some things you can do if you kind of want to on some points, but I think it's more about trying to figure out who's going to be receptive to what you're going to say, as opposed to taking a lead and somehow I got this lead now and there's no way the defense can somehow catch up no matter what I do the rest of the trial. So I don't think preconditioning should be a goal. And if it is your goal, I think a lot of times you sort of ignore assessing your jurors, and you kind of ignore and you kind of rub them the wrong way, because if you're an advocate too early, jurors start to get angry. And you piss off the judge and you piss off everybody too. So I don't think you need to do that.
What kind of work are you doing, like 4 days prior to trial? What kind of work are you doing on trying to figure out information about your jurors prior to walking into the courtroom?
Do you mean it in terms of specific jurors or in terms of getting ready for jury selection?
Specific jurors. So
in California, you do not get your jurors the list of their names or anything in advance. And I know in some states you do. So in the states that we do, we may do a little bit of social media searching and find out just a little advance of what they do. You got to find out what they do in court, but getting some research, and because you can sometimes find some useful things. I'm a big believer though in that I would rather have 5 more minutes to question a juror than to have 5 more hours to research them online, because what you find online is usually not that relevant to whatever the issue is that you're, are they going to get pissed off by this or that? And I found that, even it doesn't matter what their job, any kind of job you give me, I can find some jurors who are going to be great for your case. There's no such thing as engineers are always bad, or even executives are always bad, or medical professionals are always bad. You do want to know, like, okay, what's this person used to, and where have they worked, and what have they seen? And you can kind of craft some questions around it. And sometimes you certainly do find important things. But in California, it's just, you don't get them until the day that they walk in. And sometimes if you have to pick a jury that day, you don't get a whole lot of time to research them.
Maybe that's a blessing in disguise in some respects, right? Because we want to avoid the interrogation method, right? Like you were a part of this organization, so you must believe that, right? Like, so in some respects, it might actually be a good thing to not have too much information, because that detracts from the stereotyping, which I think is ineffective.
It's true. Yeah. I mean, you never want to stereotype a juror and kind of start pushing them toward cause when maybe they're great for you and you just didn't know otherwise. But certainly before trial, we're developing the profile, the questions we're going to ask, and what we're looking for, and what are the things that really matter, as opposed to, maybe their jobs or things like that. But most of the trials that I do, whether it's in federal trial or in California or most states, they just show up and you get the list and you're off to the races. But it's nice when you get somewhere where you get a little information beforehand, for sure.
There's some cases where we've done a jury questionnaire, right? So we would know who the jurors are, at least the clerk of the court knows who the jurors are, and you would send out all these questions and you get them about a week prior to trial, and then you get all their answers. And then you're like, okay, so where do we go with those answers? What other questions do we need to ask? And so it's kind of interesting to walk in, and I kind of like it actually, to walk in without knowing much about the jurors. Where if you're comfortable and you're able to connect with your jurors and Harry's sitting next to you to your right, you're going to do a better job than someone that's not right.
True, yeah. I mean, that is true. There's a lot of lawyers on the other side that just struggle, either don't really probe and they just sit there and they do the typical, I remember years ago, I did a podcast, probably my first podcast I ever did with Bob Simon years ago when he was the only guy doing podcasts or whatever. But we were doing like almost Family Feud style. What are the top 10 questions that defense lawyers ask? And it was the same one. It was like, can you wait till the end of the case to make a decision? And if I go second, are you going to hold it against me? And I represent a company. Can you treat a company the same? It's the same ones. They're not looking for information a lot of times. And some of them, when they just are not very good and comfortable talking to jurors. They don't get them talking. I mean, I just had a guy recently at a trial who was like, didn't seem very experienced in front of a jury. And he literally asked questions like, does anyone here have any strong feelings about politics? And nobody talked to him. And you're like, why are you asking them that? I mean, what do you expect? They're going to just, in California, they're going to start talking about Trump and Biden and stuff. I mean, he was like, nobody? Oh, okay. And then he moved on.
Strike the whole panel.
So,
strike them all. We're being dishonest.
So I see a lot of lawyers like that on the other side. Sometimes we don't want questionnaires. Now, here in California, you can do questionnaires if you can convince the judge on the other side and everyone, and it's a case that warrants it. You can do questionnaires. And usually they have the jurors come in one day, they screen them for hardship, and anyone who can stay, they fill it out, and then you have that evening to review it and come back. And sometimes you get a couple of days in advance. But yeah, you can certainly do a little bit more and kind of come up with your plan about, okay, I kind of know who we don't like. And we know the ones we need to talk to more. And you can get at least a bunch of the questions off your list, because I only really like to ask them fact-based questions. Have you ever experienced this? Have you experienced that? As opposed to, how do you feel about anything that takes a lot of explanation? I'd like to leave for voir dire, because you can't get a good sense of how they really feel based on what they write without you sitting there having a conversation, explaining it to them if they have a misconception and things like that. But I do love questionnaires sometimes, yeah.
Can you talk, Harry, about the different methods of voir dire? And I'll be more specific. There is the tribe building, the Nick Rowley, the Jerry Spence, Joey, right? There's that side of things. And then there's also kind of the Keith Mitnick deselection, go for a lot of challenges for cause right now. And I don't mean to like polarize the two. I'm sure they both sides have led to incredible results. And I'm sure if we really look in deeper, they overlap in many respects. But can you talk a little bit about the difference between the two and kind of where you see your advice leaning?
Sure. My approach is incorporate some from both. And I think you're missing something if you're not doing a little bit of both. If your only goal is to build a tribe and you're not really assessing your jurors, you're just saying, all of these people pretty much I can win over, and I'm just going to talk to them about the good things about this case and get them to all agree with some of the fundamental things that I'm going to be talking about, you're going to miss. You're going to miss some people. You're going to miss some bad jurors, and you're going to have some bad jurors on there who may be telling you what you want. But you should be at least assessing jurors. Jurors are not very good at self-diagnosing if they're good or bad for you. A lot of jurors who think that they're great for you are not going to be great for you, and even sometimes vice versa. So I think that you always have to assess them, and you have to, every panel, no matter how friendly the venue you're in for plaintiffs or your side or not, there's always going to be some people who are just going to be bad no matter how you frame the case, no matter what you say, especially leaders too. It's one thing if you get somebody who's not so great and they're kind of a follower or they're quiet or no one's going to listen to them. But if you get a really bad leader and they keep them on the jury because you didn't really assess them, they can just destroy your case. So you have to assess them. But on the other hand, I don't like the too much cause method and just causing everybody out and just talking about the negative things. And one of the things that I've done kind of differently the last handful of years is the longer I've been doing this, the more I like to lead with kind of positive questions that don't necessarily only get negative responses. It used to be my voir dire questions, I would right out of the bat be going, who hates this? Who hates that? Who doesn't like lawsuits against cities? Who doesn't like money for pain and suffering? Who doesn't like liens? Who doesn't like... And pretty soon it kind of just snowballs and jurors start talking. They just get this negative opinion, and other jurors who wouldn't otherwise be bad start raising their hands. I'm a big believer that there's a risk of getting a lot of too many false negatives for you if you just go negative and just make your case seem terrible and frame it in the worst possible way. I used to think, hey, you frame it in the worst way, you get rid of all those jurors and everyone who's left is probably great. And I don't think that's necessarily the case. You tend to get rid of people who actually would be pretty good. So I always like to start a little bit more positive by asking questions rather than, who feels these negative ways, just kind of saying, what are your feelings about whether companies should have to do this or employers should have to do that, or is that reasonable? So you get a lot of good answers and you get some bad answers, and it's not going negative. It's not snowballing in a bad way. Some of that is like building a tribe. I mean, you're sort of building a tribe out of the 60 or 80% or whatever your jurors that are giving you good answers, but you're not assuming that everyone's going to be in that tribe. You're also making sure that you make a comfortable space for the bad jurors to say, I feel differently. And you don't try to win those people over. You You get them for cause, or you can use this peremptory on them. So I think you have to be talking about the good things in your case if your jurors feel that way, which is like building a tribe. But you also have to be looking out for the bad ones too, which is focusing on the negative things. But I don't like focusing entirely on just the negative stuff. I don't mind jurors giving good points of view because you are going to get a lot of them. If your case is good and you're talking about principles that aren't so unreasonable, is quality of life super valuable? I mean, you're not going to get only one or two people so the defense can get rid of those people. You're probably going to get a lot. And that if there's going to be too many for the defense to strike them all.
On that point, Harry, one of the things I remember you talking about when I first watched you speak in TLU a couple years ago was really just the emphasis that words do matter, right? Hold them accountable. Instead of pain and suffering, it's impact on their health, quality of life. Get rid of the legal words and talk about the words that people not just understand, but associate value to.
Yes.
You know, it's funny. I actually, at one trial, I remember I kept saying, hold the defendant accountable for da. And I remembered the defense objecting and said, this isn't a punitive case. And the judge was ready to sustain it. And I was like, accountability. That's like the whole point of the civil court system, right? Like we compensate those for what was taken from their health and quality of life. And that's accountability. But it is interesting. And I've noticed that when you start deviating from the norm, some of the objections and the frustration that you'll see. And I'm sure you probably see that quite a bit.
Yeah, I've never had that sustained. I've had it a few times objected to, but here's how you do it in a way that the judges will not say, no, you can't do that. You're talking about punitive damages. Whenever you say fully accountable, whenever you say, this money would hold the defendant fully accountable, or the point of the only thing we can ask for, the only way the jury can hold an irresponsible defendant fully accountable, you always have to add, can you hold them fully accountable for the harm that their decisions cause somebody? As long as you say accountable for the harm, that's totally appropriate. Our system compensates for these things. And by compensating, that holds, if you don't compensate them anything, you're not holding anyone accountable. But you're right, without that, you start to maybe veer into kind of that gray area of, wait, what do you mean hold them accountable? It sounds like punishment and deterrence and everything like that. Even though the weird thing, you and I know, everybody knows that a compensatory verdict kind of is a deterrent, right? And jurors know that. If every time someone caused you harm, they got off scot-free, that wouldn't deter anybody.
Right.
Making them pay compensation kind of is a deterrent. So you can't really talk about those things out, those words. But as long as you say, are you open to the possibility that millions of dollars, or if your case is a little bit smaller, are you open to the possibility that a significant amount of money for someone's pain might be the right amount to hold a person or a company fully accountable for the harm that their conduct or their bad decisions or whatever caused someone. As long as you add that in, you should be safe.
And I like the phrase, are you open to the possibility? It really is an inviting phrase to get people to actually talk. This is awesome, Harry. I'm glad we have you. and I could go on for hours. I have one more question before I let Niall jump in, because there's a few questions we always like to ask people towards the end. But let's just say the young lawyer got a car wreck case, right? Not a case that warrants or can justify bringing in a Harry Plotkin, right? Or another jury consultant. What is your advice about learning how to assess jurors and construct an effective jury selection?
I used to struggle to answer that question because I found that other than some books on trial guides, and certainly Mitnick is one of the really good ones, there's not a lot of education on the jury selection part of it. So I recently just launched a podcast focused entirely on teaching jury selection. It's called Picking Justice. I co-host with Dan Kramer, a good buddy of mine, and an amazing trial lawyer out here in California. We just launched it in January with the first 2 episodes, and every 2 weeks we're going to release another episode with different guests. We've already filmed a bunch of them with Joe Freed, David Ball, Gary Dordick, and a bunch of people like that. Ibiari Sek was our first guest from California. If you know Ibiari, she's amazing.
Yeah, I saw her at the ranch.
She's incredible. Yeah. Over there. And we're just going to keep having more and more guests on. In some episodes, it's just us teaching jury select, getting more into the teaching of it. And a lot of them, it's with guests teaching their approaches. And we're really focused on just teaching everything about jury selection, sharing kind of unconventional approaches with people. For me, I think that's why we created it, so that young lawyers and people who don't have access to great education on jury selection can have something. So you can download it and stream it on our website, pickingjustice.com. It gives you all the different Apple and Spotify and all those things. That's what I would point to. But I think Trial Guides has some amazing books too. Trial Guides is incredible.
If you were to pick a few books on trial guides, which books would those be?
For jury selection, I think Don't Eat the Bruises by Minnick is a great first one to jump into. Rules of the Road is great. Trial by Human and anything by Nick is terrific. I mean, I think those are probably the best ones that I've read. A lot of them don't necessarily deal with jury selection, but some do. But I mean, getting reps is the other huge part of it. Try more cases. Don't be afraid, especially if you're a young lawyer, to try tough cases. You're doing your best you can for your client. Don't worry about losing. I mean, if it doesn't go well, that's fine. But getting reps, I have not seen a lawyer just right off the bat just get amazing verdicts from the get-go. It just doesn't happen. All of the best lawyers that you've heard about got their butts kicked many times before they became the legends that they are. And so getting reps and practicing in front of focus groups or go and watch other lawyers locally pick juries is probably the best way. There's no substitute for watching and doing it. So that's what I would definitely recommend.
Harry, getting an amazing verdict starts with the way you shape your jury. Looking back at your career of almost 1,000 cases where you assisted in picking a jury, does a particular case stand out where between you and yourself, you're like, you know what? That jury played a role in the amount of damages that we received?
Oh, for sure. Yeah. Every time. Yeah.
In which case in particular, you believe the way that y'all framed it, the way that y'all selected that jury had just such a great effect on the damages that y'all received?
Probably a couple that come to mind in terms of how we phrase it and everything. So the biggest verdict I ever picked a couple of years ago with one of my best friends, David D. Robertus. I believe it is the largest employment verdict of all time, where we sued Southern California Edison on behalf of two guys who blew the whistle on some things. And it was a tough case. It was almost a zero offer. And the verdict was $464 million. And the main question I relied on of voir dire in that case was, let's say that a company has great policies for workplace conduct. They train their employees on it. Training is great. No problems with it. What are your feelings about whether that's all really a company can do to prevent harassment in the workplace? Or should companies be required to enforce and police the workplace? And we had answers all over the place. And I feel like that really honed us in on the best jurors. And we had a couple of people on that jury that were fairly conservative seeming. We had one guy who was a former COO who was my favorite juror. And I think that was a huge part. And the reason that we asked that question was because the company's, one of their defenses was, the whistleblowers came forward. We fired these 3 bad managers. We solved the problem. What did he expect us to do? But, it had been kind of rampant for years, and then it was still kind of rampant afterwards. So that was one of the big ones.
Yeah. And what hit me there, Harry, is like coming back full circle. It's, you framed it in such a way that even if the defense is right, it still doesn't matter. Right.
Right. Exactly.
Yeah.
Another one that I'll mention that was a lot of fun, which was a really shocking verdict, was the one just a few months ago I did with Nick Rowley and Keith Bruno in New Mexico, which was, I think, was the biggest med mal verdict of all time in Albuquerque, where one of the main things we asked in that one, and it was a tough case. It was a guy who went in for medical treatment at this Mayo clinic and accepted some ED treatment. And, he came in with ED problems and he came out with some pretty private problems. But we made sure to ask jurors questions like, should medical professionals have to do any medical tests or learn about a patient's health and history before they prescribe a treatment, or they can recommend things without knowing the patient? And that was, we had a couple other questions like that where I feel like the framing and making sure that we got jurors who were going to be on board was so crucial to making sure that every one of those jurors was pissed off. I mean, it's tough to get a unanimous jury that wants to give, in that case, I think it was like $412 million verdict. I mean, even one person is like, I'm not rubbed the wrong way. They're going to weigh down the verdict. And so making sure that you have questions where you're assessing every one of your jurors and saying like, I really want to know how you feel about these things. I don't think there's a single person on that jury left that is going to say, it doesn't bother me that much. It's such a huge thing. One thing that I really would like to stress in voir dire, even if you have only a little bit of time, make sure that you talk to every one of your jurors and ask them at least one open-ended question that really tells you a lot about how they feel about the responsibilities and the conduct and everything. If you miss anybody, I'm not a good guesser either. I mean, there's a lot of times when people go, wait, what do you think about that one juror? And if the lawyer hasn't asked him anything, I can't tell you. I don't know. He might be great. He might be terrible. And I don't read minds. I've had a bunch of trials recently where the judge gave us a very little amount of time. I had one with David D. Robertus in San Diego where the judge said, you have 32 jurors and 30 minutes to voir dire them. And I just told him, David, I want you to ask this one question, all 32 of them. I don't care if it takes you 20 or 25 minutes of your time, just do that. And he did it. And I think it took him about 25 minutes. We had about 5 more questions. And I said, just ask these ones about damages. When we were done, I was like, I feel like I could assess every juror. There's nobody that I feel like I'm guessing about. We got a great verdict in the case. So even if you have a very limited amount of time, make sure you talk to everybody and make sure you have at least one question. How do you feel about this? What are your thoughts about whether companies should have to do this or not have to do this, or drivers, whatever it is about your case? Make sure you ask every juror at least one no right or wrong answer question, so you got to hear from them about how they're going to feel about what the defendant did.
I love it. Well, Harry, this has been great. This has been really great. Now, my understanding is that you've kind of limited your practice to really California, right? Like we're not going to see you in Virginia anytime soon. Is that fair?
Not in the next few years. And the reason that I do it, I mean, one of the main reasons is I have young kids. I know you have young kids too, Sharif, as well. And I just, there was a few years ago, I was flying out to do a focus group in Missouri on a Friday for a Saturday focus group. And I was like, why am I doing it? Why am I missing an extra day with my kids and then another travel day when I could have been doing a focus group in LA and seeing them that night and tucking them into bed and everything. And so until they're a little bit older, I mean, they're 8 and 10 right now. I'm sure at some point when they don't need me around all the time, I will probably be going around all over the place. But yeah, for the time being, I kind of try to stick locally.
Well, you're choosing what matters. So
yes.
Yeah, that's the important stuff. Harry, this has been awesome. Thank you so much.
Of course.
It's been a privilege.
Harry, it was a pleasure having you. And picking justice, not only will I be on it, I'm sure many of our listeners will also be clicking to listen to your podcast and gaining from the 20 years and more experience. So we appreciate you so greatly. Keep doing the great work. And as Sharif stated, you're choosing what matters. So continue to choose it. I support that fully.
Thank you so much. Pleasure, guys. You guys are awesome. I'm so thrilled that you guys are sharing all this stuff with the legal community. So it's so much fun being on with you guys.
Oh, we've got a lot to learn in Virginia. It's good. Especially when it comes to voir dire. But no, it's good. Well, Harry, I'm sure we'll see you at TLU at some point. But yeah, this has been great.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.